Thanks very much, Michael, and thank you so much for providing the facilities for this meeting. We really appreciate both the facilities and all the work that you've done to organize it. And thank you, everyone, for coming out. I want to start by introducing our guest of honor, Justice Yacoob. Justice Yacoob, I can't really express what a privilege it is to have you here with us, and I think I'm speaking for everyone here. I suspect that you don't really know the effect that you've had worldwide. I think you know a little bit about the effect that you've had in South Africa, but I wonder if you really know the extent of what you've accomplished already in terms of setting us a model of what justice can mean. And the group in here, unlike some of the other groups that you've met with so far in Canada, we are mainly people who work at the grassroots level and try to seek justice for people living in poverty and dealing with homelessness. And so we have a different kind of relationship with some of your decisions and writing than others, because we turn to it as an inspiration and as a model of something that we would love to try to accomplish here in Canada in our work. And I'm so grateful that you've agreed to interact with us in an informal way to help us strategize around the problems that we face here and to think through some of what you might be able to offer us in terms of your experiences in South Africa that might be of assistance to us. I'm sure most people know of some of the work of Justice Yacoob, but just to briefly outline his amazing biography, he came out of years of struggle against apartheid, years of advocacy on the ground, working for people facing unfair evictions, facing the injustices of apartheid, representing activists who were subject to treason trials and so on. This is a man who obviously knows what the struggle for justice is all about from the grassroots perspective. And as a judge, I guess, what I find incredible is that the two decisions which are of the greatest import for us in our work were both authored by Justice Yacoob, and I suspect that the court somehow relied on Justice Yacoob when it came to the really tough issues. The first was the Grootboom decision, and I should apologize, Justice Yacoob, for the fact that I and probably most of the people in the room as Canadians are completely unable to pronounce the name of the most important housing rights case. It's the only problem that we have with the Grootboom decision is we wish that Irene had a different last name that we could pronounce better in Canada, but at the risk of butchering it, the Grootboom decision that you wrote was absolutely transformational in terms of the world's understanding of the role of courts in relation to social and economic rights. I have quoted so many times, but I think it's worth just to remind us of the nature of that decision and what it meant to us. I pulled out the introduction that you wrote that I find every time I read it, it gives me inspiration for my work. The people of South Africa are committed to the attainment of social justice and the improvement of the quality of life for everyone. The preamble to our Constitution records this commitment. The Constitution declares the founding values of our society to be human dignity, the achievement of equality, and the advancement of human rights and freedoms. This case grapples with the realization of these aspirations, for it concerns the state's constitutional obligations in relation to housing, a constitutional issue of fundamental importance to the development of South Africa's new constitutional order. The issues here remind us of the intolerable conditions under which many of our people are still living. The respondents are but a fraction of them. The case brings home the harsh reality that the Constitution's promise of dignity and equality for all remains for many a distant dream. When I read that, I think, why can't we read decisions like this in Canada? You know, there were moments when we became a constitutional democracy when we had that kind of inspiration and motivation and eloquence from the judiciary, glimpses of it. But why have we lost it? Why do we not get to read things like that now when we have lots of issues that would really warrant the same kind of eloquence, although we don't have quite the same kind of legacy of injustice and poverty and homelessness as in South Africa. We certainly have issues that we're grappling with, and it's so important for us to have a judiciary that could learn from someone like Justice Yacoob about what the real role of courts can be. And the other decision that we often turn to is the more recent one that Justice Yacoob authored, was the Olivia Road, the occupiers of Olivia Road, where Justice Yacoob really articulated for the first time the obligations of governments to meaningfully engage with homeless people who are facing eviction into homelessness, but more generally the whole concept of meaningful engagement with rights holders and the role of the courts in facilitating that and making that happen. So we find ourselves throughout the world turning to these two decisions authored by Justice Yacoob as really articulating the fundamental procedural and substantive rights that so many of us are struggling for in very different contexts with different constitutional frameworks, but really all oriented around those words that Justice Yacoob wrote at the beginning, which is that we're struggling for dignity and equality and security in the context of all sorts of different realities and different constitutional frameworks. So the hope today is that despite some of the differences between South Africa's constitution and Canada's, that we can share some of our experiences and think through what we can learn and be inspired by from the experience in South Africa. And I just want to thank Justice Yacoob again for coming, and I want to extend our warmest gratitude and welcome. Thank you very much for coming. Now I'll just quickly introduce the three panelists that we have that are going to enter into a kind of conversation with Justice Yacoob, and then towards the end of the session we're going to open it to the floor and we'll have an informal conversation with everyone else. And after I introduce the panel, I also just want to quickly go around the room and hear from people, just quickly give their name and affiliation so we know the kind of friendly crowd that we're actually here with. So on my right is Ruth Goba, who was the executive director of CIRA, the Center for Equality, Rights and Accommodation, has done work on the right to housing internationally in India, and is most recently a commissioner with the Ontario Human Rights Commission, and was very much involved in getting the Ontario Human Rights Commission to engage very constructively in issues of the right to adequate housing and getting their report right at home through all sorts of hurdles. And it's great to have Ruth with us today to engage a little bit with the role of human rights commissions and to think through some of those issues for us in conversation with Justice Yacoob about the kinds of experiences they've had in South Africa. And then to Justice Yacoob's left is Leilani Farha, who is the Executive Director of Canada Without Poverty. She also came from CIRA, the Center for Equality, Rights and Accommodation, as a previous Executive Director there. Leilani has had all sorts of experience also internationally that people in Canada may not be quite as aware of, but just to name one, she, as a fairly young woman, took charge of getting the resolution on women's rights to land and property through the UN Human Rights Commission, which was an incredible accomplishment. And I can actually say that the UN would not have the understanding that they have of women's social and economic rights and women's right to housing if it weren't for the groundbreaking work that Leilani did in her early years and continues to do, of course. And then finally we have Craig Scott, who everyone will know now is a member of Parliament from Toronto Danforth, having won the by-election in Jack Layton's old riding. And Justice Yacoob, Jack Layton was the previous leader of the NDP, and homelessness and the right to housing was one of his focal points. And so Craig has stepped into a riding that has a strong tradition around the right to adequate housing. But those of us working in the area of social and economic rights will also know Craig as the leading expert in social and economic rights in Canada. In his academic career, he was a professor at the University of Toronto Law School and then at Osgoode. And just to mention one thing, Craig was the leading co-author of an article called Ropes of Sand about whether it was written for South Africa during the discussions about whether the Constitution there should include social and economic rights. Had a tremendous influence, and I still find that when I go back, when I think I've thought of a new idea, I go back to Ropes of Sand and find that Craig had already kind of covered it there. It's a lovely article, and I'm sure had some influence. I know Justice Yacoob sat on the technical committee of experts for the Constitutional Assembly, so he may be able to fill us in, but I'm sure that article provided some useful guidance to the Constitutional Assembly in thinking through whether to put social and economic rights in the Constitution there. And I subsequently had the pleasure of going to South Africa with Craig when some of the NGOs were trying to debate these issues and so on. So Craig has a history of social and economic rights in Canada, social and economic rights in South Africa, and now, of course, he's going to bring in social and economic rights as a parliamentarian.
No pressure.
So if we could welcome this prestigious panel and thank them for coming out, that would be great. Great, well, thanks very much. And Anu, I'm sorry, I should have also welcomed you. This is the problem with, but thank you so much for accompanying Justice Yacoob and coming with us. And I had the pleasure to meet both Justice Yacoob and Anu in Pretoria several years ago, and really appreciate both of you having come this long way. And also, I should have mentioned that Vince Calderhead deserves a mention of thanks too. Vince, with Nova Scotia Legal Aid, was the main organizer for Justice Yacoob's tour and has worked feverishly over the last several months to manage to put everything in place. He's gone out to Vancouver today, but I know he's been part of most of the previous events, and I also want to acknowledge his help. I thought maybe we could start off, Justice Yacoob, by just maybe having a brief comment from you. I thought I would put the question to you that as you've probably heard that Canada, and certainly experienced, that we have none of the kinds of massive issues of squatter settlements or hunger or the HIV/AIDS crisis or any of the kinds of matters that you've had to deal with and grapple with at the Constitutional Court. And yet we do have, in the midst of this affluence, we have 300,000 people or so who are moving in and out of shelters and suffering homelessness in a cold climate and very severe health consequences from that. We have 800,000 people relying on emergency food banks every month in order to try to feed their families. In a country that, as you could imagine, could easily afford to make sure that that kind of thing doesn't happen. Now, we have a parliamentarian on the panel, and we're certainly raising these issues in Parliament and going to committee, and organizations like Canada Without Poverty is urging political action. Human rights commissions are trying to get governments to pay more attention to these issues, but is there a role for the justice system in addressing issues of poverty and hunger in an affluent country like Canada? And if so, what would that be?
Thank you very much for those wonderful words of introduction. It is really wonderful to be here. It's a cold place with wonderfully warm people, and certainly the warmth of all of you cancels out the cold quite decisively. And it's actually wonderful to be here with the panel, and a privilege to be talking to so many colleagues around here who are interested in the broader effort at achieving some kind of justice in this country, and I suppose they'd also be interested in a kind of global justice within which we see things. It's a wonderful privilege to meet hardworking people who are not selfish in the way in which they approach things, and who are interested very much in creating a better society for Canada, which would obviously relate to creating a better society in the world. I'm really privileged and honored to be talking to people who don't simply talk about it, but go ahead and try to walk what is this very difficult road which we have to traverse in order to obtain things. Now, I want to start by saying that social and economic rights, people say, are important in poorer countries where a large number of people suffer from inadequate housing, healthcare facilities, social services, and so on, and inadequate employment. The implication of that is that somehow these social and economic rights are a little less relevant and a little less important when it comes to countries like Canada, where the problem is seen to be a particularly small one, and the argument works its way through in kind of percentage terms. So you take your whole population of 30 million odd, and then you say, well, only 300,000 people are in trouble. That equates to a little more than 3% of the population, and therefore the problem is a small one. That is customarily the argument. The second argument is that they somehow built into our analysis the idea that people don't have jobs because they are lazy. Sure, some people don't have jobs because they are lazy, there's no doubt about that. But fundamentally, the fact that people don't have jobs is in a sense a factor of the way in which society is structured by the majority of us. So it is the structure which is responsible, and in a sense it is those who benefit from the structure more who are actually more responsible for the negative consequences of that structure. So I think one must see housing as a negative consequence of a structure of society that we ourselves have chosen, which gives rise to the problem. And that places a slightly different complexion on things. The second issue is that when dealing with human beings, one doesn't talk about these issues in a quantitative way, because the issue is really a qualitative one. And the fact that 300,000 people are in and out of shelters and who suffer considerably, if one looks at it from the point of view of 300,000 human beings, families, children, men and women, weak people, people with disability, and so on, it takes a very different, you see the problem very differently then. And the next point is that because it is only 3%, it should be a problem which is in a sense more easily soluble than the problems that exist elsewhere. The notion that poverty is a problem to be addressed only in countries where the majority of people are poor, I think is a notion which simply has to be stated to be rejected. Poverty is poverty wherever you find it. Suffering is suffering wherever you find it. And in a sense, if there's one message which the South African Constitution gives out by incorporating affirmative action and social and economic rights in our constitutional order, it is this. The message is that in the South African society, and this should be the message in every society in the world, that democracy results in a value system which makes us understand that we are no longer involved in business as usual. In other words, democracy has reached a stage where it should begin, and our society has already begun, by definition, to reject the law of the jungle as the way in which we do things. And the law of the jungle, as you well know, is survival of the fittest, survival of the powerful, survival of the richest, and a non-concern for the weak and the poor and so on the basis that they are responsible for their own condition, and what happens to them is basically their business. That is their particular definition of democracy, and I think we've moved away from that. We now say that the law of the jungle is no good for us. We now live in a caring society, should do, anyway, in which strong people look after the weak, in which people who have the means care for people who don't have the means, and in which we want to create an equitable society in which there is a certain minimal standard of living that people have. Not because we feel sorry for those people, but because as powerful people, we really don't want to live in the kind of society which tolerates these things and which refuses to face up to the negative, inevitably negative consequences of its own structure and its own doing. So really the message is, And it should be a message to the world that the world should develop into a society in which vulnerable people, poor people, weak people, people with disability, they all fall in the same category, are not ignored. And I think that's the context in which we try to answer the question of whether the justice system has a role. Now, of course the justice system has a role, particularly because constitutions and legislation ought to be interpreted in their context, ought to be interpreted in the context of societal values today, and therefore it is important to ensure that appropriate societal values are taken into account in the interpretation of our legislation. So justice most certainly has a role, but what I want to emphasize here is that justice alone and the courts alone will not cut it. And that is because courts too have to be guided by what one may call the mores of the community. I heard a story yesterday which said that in Halifax, no, not in Halifax, in Calgary, that's right. In Calgary, some years ago, they said, well, only 3% of people need houses, the majority can afford it, so let's try and do something about it and give people houses. And somebody said, in relating the facts of this to me at the university yesterday, that the majority of the community reacted with moral outrage. And my response was that the moral outrage was the outrage of the rich. It could never have been the moral outrage of the poor in a way. So one of the things one of the important things one has to do through one's campaigns and so on is to change the values of our society in which we are. When we use law as a weapon for the achievement of our democracy, we were very clear that law is one limited weapon and it is part of an overall strategy. So when you use the law as a weapon to achieve justice, which one is obliged to do, one is not likely to succeed, in my view, unless the legal weapon is part of a broader artillery, and unless we make sure that the cases we bring are part of an overall strategy coupled with other things that people do, other actions that people take. So I think the idea of lawyers going it alone is quite a nonsensical idea. It works only if we as lawyers understand that we take instructions from the struggle for justice in the same way as other lawyers take instructions from their client. So we have a broader instructive philosophy, and we need basically to work through that quite carefully. So I just wanted to emphasize that there is an important role, the role is fundamental, but campaigning, developing awareness, developing the consciousness of people, organizing on a day-to-day basis, however difficult it may be to organize, persuading more and more people to be on your side, and changing, in a sense, the Canadian milieu into one in which more and more people say, we are not prepared for our own sakes to live in a society where people suffer so miserably. And I think it is possible in this day and age to ensure that more and more reasonable members of society are able to change that and to change their morality. And unless we go there in rich countries, unless we develop that understanding, my own view, unfortunately, is that the law as a means of achieving justice will by itself not cut it. In fact, it may just be counterproductive. I think I have to stop there.
Well, thanks very much for that. I'm going to swing the microphone over to Leilani because I think that...
Yes, thank you so much for those comments, Justice Yacoob. They come at a very timely moment in my own personal work, I have to say. I'm engaged at the moment in a struggle to have a piece of legislation adopted. It's called Bill C-400, and it deals with homelessness and inadequate housing in this country, and it tries to create a dialogue. The bill itself tries to create a dialogue between the different stakeholders who might have something to say about how we could address homelessness and inadequate housing in the country. And your comments are appreciated, because I'm also engaged in this case that you keep hearing us talk about, this charter challenge to homelessness, or the right to housing case, or people refer to it differently, but basically it's the case that challenges, and I know you are aware of it, the failure of the Government of Canada and the Province of Ontario to effectively address homelessness and inadequate housing as violations of our charter, particularly the security interests of homeless people and people facing housing insecurity, as well as the equality interests. What I want to talk about or ask you about is really related to that case. When we set out, and there was a group of us who set out to launch the case, we were very clear that we could not do the case without being in stride with those who are actually affected by homelessness and housing insecurity, that it would be impossible to move forward, and we wouldn't want to move that case forward without, as I said, being in stride with those who were most affected. And so the strategy we had adopted beyond the legal strategy was to ensure that community groups, grassroots groups, and those affected were meaningfully engaged in our process of launching this piece of litigation. And ACTO, the Advocacy Centre for Tenants in Ontario, took that very, very seriously and worked hard to make sure that happened effectively. And so while our sense was that we had to proceed that way, it's not the sense that we necessarily get from government or from the courts. There is a way in which, at the government level, NGOs and advocates are perceived as, we're not respected. I'll be blunt. We're perceived as the enemy, often hostile enemy. And even within the courts, there's a way in which there's been a kind of clamp down on who can intervene and whether community organizations with vested interests in the issues have the right to stand and intervene in these important cases, like the social rights case before us, dealing with homelessness. So, I then read your decision in Olivia Road, and you take an entirely different approach from my reading of it, as Bruce mentioned, in what I feel is a unique approach, and maybe, in fact, we could say a model approach to the interaction between community groups, mobilization, and the courts. And if I understand correctly what happened in that case, the litigants were actually sent away before you heard the case to discuss and negotiate with government and see if a plan could be, in fact, developed. It was an evictions case, and a plan could be developed without actually recourse to the courts. So that to me is pretty, it's not what I expect of a court generally. I don't think most people would expect a court to do that in the first instance. So I'm really interested in your concept of meaningful engagement, and how you come to it, and how you, as a judge, understand the relationship between community mobilizing and social rights claims.
Well, let me just say how we get to the reasonableness analysis. The starting point is Section 26 of the Constitution, which obliges the state to take reasonable legislative and other measures. And in the process of defining reasonableness, we said two things in Grootboom already. We said first that every step in the process of the development of housing must be reasonable. In other words, in the development of housing and in the provision of housing, the state must act reasonably. And we said already in Grootboom that the government has the obligation reasonably to engage with people before it takes reasonable steps in relation to housing. My disappointment actually was that even though this was stated right out in Grootboom, it was just an expansion of Section 26 of the Constitution, my surprise was that no lawyer ever later took the point. So we had to take the point ourselves. One would have expected lawyers, instead of saying how good the judgment was, simply to have examined it from the point of view of what leads were there in the judgment, which they could take further in the development of the law. And there are many more leads like that. So that's how we actually got there. We took the reasonableness in Section 26 and said the state must act reasonably. Every step in the provision of housing, and because this was involved with the provision of housing, the state had to act reasonably in terms of Section 26. And one of the reasonable things it had to do was reasonably engage with the people to whom it provided housing. But the obligation, I must say, was two ways. It was not only the government that had to reasonably and meaningfully engage with the people, but the people too had to meaningfully and reasonably engage the government. And the judgment makes it very clear, because, you know, we mustn't live in a fool's paradise and think that the government is the only unreasonable party in these sorts of negotiations. It quite often happens that communities become unreasonable too, and therefore the balancing act is quite an important one. And we said further that when the matter comes before us finally, they must report to us. There was no such thing as without prejudice engagement behind closed doors and so on. It was to be a process on which the parties were to report to a court, and the court was to take into account the contents of the report and the degree to which the parties had engaged reasonably with each other, either or on either side, to come to a conclusion in relation to the case finally. So that's how we actually got there. And I think that it's not too much. For a country like Canada, the issue is a different one, which is, can the majority government in today's democratic era do precisely what they want, how they want to do it, plainly because they are in the majority? And I think what we've got to do, because asked that way, the question yields a lot of trouble. Because I think the answer has to be, in a modern democracy, that it is not the quantitative aspect which counts, that governments don't suddenly get full authority if they get 51% of the vote, with the other 49% told to go to hell, whatever their views may be. In a way, the government has, then there must be a floor level below which governments should not go in the actions which they take. And I really think that it's possible in modern democracies to develop the notion that whatever the majority that government has, there is a level of reasonableness below which governmental action can't go. And we have the starting point for it in the administrative action cases. And it's a very interesting stretch to ask the question, and all of us need to ask it in the work that we do. What's wrong with saying that majority governments must act reasonably? You start raising the debate and talk to everybody and see whether we can change the scheme of things, change the way in which society thinks about things. And if you speak to the ordinary person and you say whether he is a supporter or she is a supporter of the majority party or the minority party, I think that in today's day and age, it will be very difficult for any person in Canada with a modicum of civilization to say that majority governments have the right to act unreasonably if they so choose. It's a very difficult thing, and it may be that this reasonableness area is something which in modern democracies must apply not only to administrative action, but could constitute, if we create the right basis for it in our communities and societies, some kind of test by which government is bound, even if it represents the majority. In other words, the notion that governments govern the whole country. They don't simply govern the majority in the majority's interests. Once they get into power, they've got to govern for everybody, and it's a misstatement of democracy to say you go to Parliament and act only in the interests of the people who voted you into power. You've got to act in everybody's interests, and that probably is the beginning of the reasonableness standard, I suppose.
I think what Justice Yacoob has just said in the last, everything he said has been extremely inspiring and acute at the same time. What he said in the last third of his comment just now is really important, because from the perspective of somebody who's now a legislator, so-called, and I say so-called because in our system we effectively have a one-shot vote democracy now, in two senses. One is we have a perverted electoral system that means you go to the polls and you vote, and you may just have, one way or the other, participated in something that with 40% of the vote, a party gets into power with over 50% of the seats. And so you're kind of, the suggestion is, okay, you voted, and now let Parliament and parliamentary democracy take over. You guys come back 4 years later. That's extremely stylized, but that's quite close to the reality of how party politics in our Westminster system is currently looking at people as citizens. And the whole idea of democratic engagement is probably further off the radar screen in Canada as something that's closely tied to institutional politics than it is in many other countries, from South Africa to New Zealand to Australia. We have, we're well behind the times. But the one-shot vote democracy also is apparent in the way Parliament works, because exactly what Justice Yacoob talked about does occur. It has occurred in the past in majority governments, but never to the extreme that we see now, where the idea is we have the majority of the seats. Every vote is predetermined because we have a lockhold on our own bench. The Prime Minister's office controls everything. There's executive domination there. And then that just filters down into constant majority votes, complete unwillingness to entertain amendments at all. Committees are democratic microcosms. We hear an awful lot about the problems of legislation. It's valuable to the extent the media pays attention. It's part of a public record. The debates that go on in the House, where frankly it's an exchange of speeches, are also important because we put things on the record, but none of it matters in terms of the outcome with the way our combined electoral and parliamentary democracy works. So at so many levels, we have to take up the challenge that Judge Yacoob talked about, which is the idea of reasonableness and governing for everybody pervading all aspects of democracy. And that's why I've always thought about, and I should say I'm now the official opposition critic for democratic and parliamentary reform, which is what I wanted from the beginning when I was elected in March. And I see this discussion right now as helping my thinking even further on one pillar of what I'm trying to do that will be rolling out in about a month on a democratic reform agenda for Canada. That's the democratic engagement piece. I've always thought of court cases as participatory democracy in a very important way. Opportunities for those affected by structures and broader decisions that either don't care about them or just haven't thought about them, to have a say in a way that can make a difference because of what the courts might be able to do. And at that level, I've often thought of courts as the democratic conscience of legislative and executive branches. And I've always insisted on that, even when you have this incredibly crude pushback coming from sort of U.S. Republican thinking, and now it's quite embedded in our discourse, of courts as anti-democratic, simply because they're appointed, for example. And a near villainization of the role of the courts coming from a core part of the governing party, and an attempt through the appointments process to increasingly appoint judges who really aren't going to play the role of being the conscience of society. So I guess my question is to Justice Yacoob, I can't imagine that there's not some version of the same problem in South Africa. There may be more of a cooperative culture in Parliament. I'm guessing maybe not necessarily. And there may be more openness to what the courts are suggesting by way of nudging or spotlighting through their judgments. But do you have any sense that in a world where we can't expect the courts to do everything, they have to play a role in tandem with the legislature and the executive, are there parliamentary reforms that you, from the position of a judge, with all the experience you've had, would welcome as a way to interact with what the judicial system can do and the limits of what the judicial system can do? Are there ways that a Westminster style, or I know South Africans is more hybrid, democracy can be structured at the parliamentary end to take rights more seriously in a way that's going to make the judicial legislative dialogue more productive?
In South Africa, it's certainly possible because the ground floor in the South African Constitution is that government must comply with the Constitution. The Constitution has the Bill of Rights. It has the right to socio-economic rights and so on. So that the strictures on the parliamentary process requires minorities to properly be taken into account in the course of debates and so on. So the debate is somewhat more open. You get bills changing as a result of debates and so on. But there is a bit of a problem, because although court orders have been obeyed, there has been a lot of talk lately by the ruling political party as if they are the judges of whether separation of powers have been impinged. They forget that the courts decide those questions. So there have been lots of allegations against the courts that they are impinging the separation of powers principle. There's been a lot of concern about that from many quarters. Concern also about the fact that the ruling party wants a review of the judgments of the Constitutional Court and the Supreme Court of Appeal. That's been in the press quite a lot. But I think that the concerns about that sort of thing are ill-founded. Ill-founded because, as far as I'm concerned, it's part of the democratic process for Parliament, if they wish to review the judgments of the Constitutional Court in order to determine whether perhaps the Constitution has conferred too much jurisdiction on the Constitutional Court, and whether perhaps the powers of the court should be cut back, or whether perhaps they should have another mechanism within which to do it. Because after all, the courts derive their power from the Constitution, which is really a democratic instrument adopted by 90-odd% of the people. The Constitution itself provides that in matters of importance, like the structure and functioning of the courts, they require a 75% majority to get it changed. So in the process of deciding whether courts are working well, in my view, and that's where this conversation takes place, Parliament and the executive are totally within their rights to cause an evaluation of the work of the court. And if they come to the conclusion that there is something in the work of the courts which the legislature or that is undemocratic and should not be authorized, then it's within their right to try and get 75% of the vote to change it. I don't have a problem with that at all. Finally, of course, it is the Constitutional Court with its current powers which will have to determine whether the amendment is constitutionally permissible or not. so that in the final analysis there doesn't seem to be too much difficulty. So there are two strands. There is a strand of review, but there's also the strand where people do, where Parliament has responded to the court and done what it has to do. There was a recent case where the opposition wanted to have a vote of no confidence heard urgently, and they didn't hear it. The majority party used its whip and said, no, we're not going to hear this vote of no confidence in the president, actually. We're not going to debate this. And they came to the court to ask that they be debated. The court refused. They came on an urgent basis to our court. And we refused to hear the case urgently, but we directed Parliament and the Speaker of Parliament to ensure that the rules of Parliament effectively dealt with how votes of confidence, no confidence should be dealt with. There should be a proper procedure which should then thereafter be tested for its constitutionality. And Parliament is about to draft a law. I think the law will come out in a month's time or something. And then the court will, the Parliament will report to the court, and the court will look at it and see how far, whether the legislation has gone far enough. So there is talking, but there is obviously, as is to be expected, a great deal of discomfort. It's not only here that politicians harangue judges and so on and so on. My view is that it's par for the course. We as judges should be strong enough to bear the criticism. We will be strong enough not to respond, not to over-respond to it. And we as judges should be strong enough not to be affected by these things and to remain independent, because that's how, and that is why we are appointed. So there's no point in saying politicians should not be saying this and should not be saying that. It's their right to say whatever they want to say. It's part of the conversation, as long as we are not unduly affected by what politicians say in the judgments that we give.
I guess this issue that Craig raises about taking rights seriously, and certainly if you think of the Olivier Road model, you know, when you require that there be meaningful engagement between the occupiers and the government in terms of working out some sort of solution, I think what's empowering about that model is that you say that the solution has to be in conformity with fundamental constitutional rights. So it changes the relationship between the citizen, the community group involved, and the government, because they've been empowered by your instructions that this engagement has to be rights-based. But I guess
we do it because we are the link with democracy is very important, because courts do it and we do it because we are obliged to do so by a constitution which was adopted by 90% of the people in 1994. So there is a democratic link. You see, the notion that courts function undemocratically is a bad one, because we are authorized by a democratically accepted constitution to do it, and until such time that there is a sufficient majority to replace our mandate or to change it, we will continue to be authorized by the constitution to do it, and therefore we perform a democratic function.
Mm-hmm. I mean, one of the things that we struggle with in Canada, I think, is that, you know, we can't rely on our courts to create this rights culture, to insist that rights be taken seriously, particularly around social and economic rights and issues of poverty. In fact, they often would suggest the opposite. You know, they just keep quoting Peter Hogg, who quotes Oliver Wendell Holmes, these are matters best left to Parliament and the legislators. So it's a way of kind of reading rights out of these issues and making them mere policy issues that where the legislators have complete freedom. And in a way, it strikes me that leaving it up to, we're desperate for institutional mechanisms to sort of protect democracy and to ensure that rights are taken seriously. And one of the crises I think we have in Canada is that we did rely very heavily on human rights institutions, human rights commissions, prior to our Charter of Rights, as institutions whose mandate was to promote and protect human rights and to ensure, to kind of play a middle role between civil society, often the community groups are under-resourced and unable to play the role on their own, and they would need the kind of the official sort of support of human rights institutions. But Ruth, I get the feeling that that's one of our problems at the moment, is that I don't know that we're getting very far in figuring out what other institutions can support the courts in taking rights seriously.
Yeah. I think that one of the challenges for human rights commissions is to find ways to maximize the potential of their statutory mandate to promote economic, social, and cultural rights. And at the beginning of your, when you first started speaking, you talked about the law being one aspect of the way to do that. Our commission here, our commission in Ontario, has a fairly broad mandate, which includes public education, research, statutory review. I think kind of a holistic approach to ensure, I think those things balance the litigation and assist with attitudinal change, which is extremely important when you're looking at human rights. And I wonder if you can comment a little bit on, Bruce has already, I guess, alluded to this, but what role human rights commissions can play. And I ask this with particular reference to the commission in South Africa and the role that you gave that commission in Grootboom, which was to monitor and report on the state's compliance with its obligations under Section 26. And for those of you who don't know, Section 26 of the South African Constitution guarantees the right to adequate housing. And Justice Yacoob has already mentioned a little bit more about it. I wonder if you can tell us whether that strategy was effective, and if it was, how so, and if not, what roles you see for commissions advancing ESCR where their mandates may be somewhat restricted.
But first I want to complain about being discriminated against at the hands of people who take human rights very seriously. Ruth is Ruth, Melanie is Melanie, but I'm Justice Yacoob. That's no good. I think you should just call me Zak and sort it out that way.
You had me worried there for a minute.
It's a fair complaint, right?
Yeah, absolutely.
All right. So I think the role that conditions can play depends on the circumstances in which commissions find themselves. It's not simply a question of the interpretation of the law, but where society is at a particular point in time. And that's why I will find it very difficult to answer that question. I'll return to that in a moment. South Africa was a more complex issue because we didn't make an order that the Human Rights Commission should report to us. We were very gentle about it and said in the judgment that there is no need, because we were trying to tread very carefully. It was the first judgment and it was the beginning of the conversation and so on. After that, we've compelled government to do things after that quite a lot. But in that first judgment we said there is no need for us to compel the government to do anything. We do have the Human Rights Commission. We are sure that the Human Rights Commission will take its responsibilities very seriously. And we said we have no doubt that the Human Rights Commission will report. We have no doubt that if necessary and the government is not doing its thing properly, the Human Rights Commission will bring the necessary proceedings in a court of law if it is necessary at any point in time. Trouble is that we were wrong on that count. I would have thought one of the important roles of the Human Rights Commission would be to define carefully what human rights are, and ultimately to define that by taking into account Canadian conditions. And yeah, I turn to this very difficult question, which people have made very difficult, whether the right to have a home is a human right. and whether this distinction between social and economic rights on the one hand and civil and political rights on the other holds true, and whether rights are properly said to be interrelated, and whether it is in fact true that when you are poor and you have no home and you have no food and no water and things are very difficult for you, the idea of your exercising civil and political rights becomes not such an acceptable one, because people have to have certain basic minima to exercise their rights. And what I see, I mean, for me it's changing the critical mass, and what I would see as a role of the Human Rights Commission is an educative one, to change thoughts and ideas of people, and not to confine themselves, I would say, to writing articles and writing reports for the consumption of government and writing highfalutin things which only academics would read. But in a sense, I think that the Human Rights Commission must educate by raising these ideas, having meetings around these ideas, consulting around these ideas, going to the media on these ideas, having publicity in the media, and so on, so that you consult everybody, and thereby enliven the issue, and consult people about what human rights should be, consult people about whether a home is a human right, having a home is a human right. Put your views forward as to what you think, and ask people to respond to what you have to say. Hold meetings on it, hold conferences on it, get publicity on it, so that you get the opportunity to change. So it's not an education of the government issue. It's not an education of academics issue. I think it's really the issue of public education, a vibrant public education campaign in the human rights arena, because you can quite easily say, I don't know how feasible it is, but that is the only way in which human rights can be understood by everybody, in which human rights can be meaningfully conveyed to everybody, and in which we can develop a critical mass of people who understand human rights and who understand their importance. And I would see that perhaps as an important part of the Commission's role.
I think we can put it open to the rest of the room for discussion. I just want to maybe put one question to you in the context of some of the work that we're doing here. There's a number of people here who are working on the right to housing Section 7 case that you've heard about, where we've got a lot of civil society engagement, but dealing with a court that is going to very quickly raise issues of separation of powers and so on. And I'd be interested in, so that's one of the things that a number of us are working on. And it's accompanied, as Leilani noted, by a political campaign to try to get the remedy achieved through democratic parliamentary procedures rather than through democratic judicial procedures. It looks as if that's probably going to fail in the next 2 weeks, but we're still hoping for a different outcome. So we've got an interesting dialectic between the political and the judicial on that case. Another issue that I hadn't mentioned to you before, but a number of people here are working on, is we don't have squatter settlements and occupiers being evicted here, but we have probably about 20,000 a year just in Ontario. Households evicted, many into homelessness, and about half of them owe a month's rent or less. From the data that we had from a few years ago, and it's probably about the same. And so we're, and as you've probably sensed from discussions with some of us as you've been in Canada, we have to here rely so much more heavily on international human rights obligations and on the jurisprudence that suggests that those inform reasonable decision-making as well as inform the scope and the nature of the rights under the Charter. So what we're looking at doing on these, before the Housing Tribunal, is to suggest that the kind of jurisprudence that has evolved in South Africa some of which you've authored around evictions into homelessness. And, you know, in Olivier Road, the High Court did rely on international human rights obligations in that case. You know, we welcome the fact that South Africa has finally ratified the International Covenant on Economic, Social, and Cultural Rights. So you're now a party along with us. So I guess what we're going to be doing is going before tribunals who have never really even heard social and economic rights arguments, and certainly haven't thought of it as part of their role. And we're going to be trying to get them to take these international human rights obligations seriously in terms of how they should exercise their discretion. And I guess the question is, from the standpoint of being on the bench, when you're dealing with, and you must have had some interactions with colleagues where there's a real reticence to engage in these complex social and political issues. Why should the judiciary get involved in it? What is it that you would advise us in making these arguments, either in the constitutional case before courts or even appearing before tribunals? What are the arguments that really resonate with you and with your colleagues, and which ones tend to go awry?
See, it's a difficult question, because let's talk about evictions first. Evictions and homelessness are related, and therefore housing rights are not only about giving people homes, they are also concerned with evictions. So we have a very interesting provision in section 26(3) of our Constitution, which says that no one may be evicted from their home without an order of court made after taking into account all the relevant circumstances. So in a sense, our Constitution has made a distinction, clear distinction, between eviction from a home and eviction from business premises, signaling the importance of the home and making it quite clear that the occupation of a home is some kind of human right. Now, the last judgment I wrote before I left the Constitutional Court, and which was delivered, I think, last Thursday, was the case of Motswagae. Again, pronunciation trouble. Motswagae. Quite an interesting case. And that case was about, if I may take a minute to tell you, that case was about the government who, in the process of developing housing and upgrading property, went onto a property occupied by people who had their homes on it, in order to provide, without evicting people, in order to provide infrastructure for the future housing development. And the work that they did meant that they went in with a bulldozer and bulldozed right next to the wall of the house, and exposed the foundations of the house. Such was the level of interference with the right to occupation. And we held there that section 26(3) must be broadly interpreted, and it also includes the right not to have your occupation interfered with, the occupation of your home interfered with in any way. What the government did there was that they interfered with their accommodation, and in the same breath, the stick and the carrot approach, offered them alternative accommodation, which they didn't take. And we said quite clearly that it's quite clear that this was a strategy to have them evicted doing both these things. And this was an improper way to go about things. It was unconstitutional, it was unlawful, it was unreasonable, it was contrary to section 34 of the Constitution, which, according to our law, prevents people from taking the law into their own hands. And this was clearly the municipality taking the law into its own hands. And we said they can't do so without a court order, and desisted. Now, interesting thing about that case is that although the way we put it, it sounds very obvious that they can't do it, the High Court actually ruled in favor of the municipality on the basis that they were doing a very laudable thing, and that is that they were doing housing development. But we came back to our case and said, well, every step must be reasonable, and of necessity an unlawful, unconstitutional step in the process of performing a constitutional function doesn't legitimate it and make it lawful and constitutional. So that's the most recent case, which might bear looking at. It's short, mercifully. It's not more than 11 pages or something. So you'll be able to look at it quite quickly. But that brings me to Section 26.3. And a law which we have, which says that when people are occupying their homes, lawfulness of occupation is not necessarily the only criterion. In the old days of positive law, even if the person was occupying their home, the law was not only that the person must lawfully occupy, but the law also was, and I don't know whether there is such a positive law here, but the law in our country also was, even in the case of people occupying their home, that where the owner is suing for eviction, the onus is on the tenant, to the occupier, to show that he has the right to occupy. And that's a phenomenally bad law, because what it meant was that if on the basis of all the facts before it, the court found it impossible to decide whether the occupier had a right to occupy or not, the occupier would be evicted. Now, there are lots of people who've moved into the fringes of the town and so on, and we've had lots of cases on which indirectly concern Section 26.3, because what would typically happen is that people would be unlawfully occupying property owned by other people or property owned by the state. It's a little easier when it's property owned by the state, because you say to them, it is reasonable to say to you that you can't evict people from your property unless you do something about it. And there's a law in our country now, in terms of Section 26.3, which says that unlawful occupiers of their home can only be evicted when it is just and equitable to do so. We brought in the question of justice and equity, and the legislature has done so, as distinct from mere unlawfulness, which is the positive law. So it's very interesting to see whether it is possible to develop the idea amongst the critical mass of people in South Africa, in this country, that when people occupy their homes and when they are being evicted from their homes, justice and equity should play some kind of role in the process of the decision making, and that a court should have a discretion to decide how justice and the factors in relation to justice and equity operate by taking into account the competing considerations, the rights of the owner, the rights of other people, and so on, and how we do it. Typically, the sorts of cases we've had is involving private parties. Is people would be, hundreds of people would be in occupation, sometimes a couple of hundred, sometimes a couple of thousand, of property of owners, and have been in occupation of those properties for 10, 12 years, 15 years. The owner has not sought to develop the property, and in fact, the occupation occurred precisely because the owner had done nothing with the property and had left it lying idle. Now the owner would sue for eviction. The occupiers would join the municipality and say, it's the municipality who has to give us houses before we leave. The municipality will say it's not in the circumstances obliged to do so. So you get a tripartite fight coming before the Constitutional Court. Typically what we've done in those cases is to emphasize that the ownership of property, the owner's right to property, has been qualified by our constitutional order now, and the rights of people to occupy their homes and so on must also be taken into account. So we've sort of qualified the rights of owners of property occupied by tenants. Not too much though. We've said owners must be patient and the municipalities must play their role and so on. And we've typically settled these cases and made orders where we, depending on the circumstances, have said the municipality must provide houses, say within a year, sometimes within 2 years, sometimes within 6 months. And we've coupled the date of the eviction to the date by which the municipality was authorized to provide housing. And we've done that, and that's worked interestingly enough. It's very interesting to see whether in Canadian society it is possible for a critical mass, with the publicity that the Human Rights Commission would give too, that eviction from a home is different from eviction from a building, that eviction of a person who earns $15,000 a month from a home where he pays $5,000 a month rent and can afford to do so is a different matter from the eviction of a woman and 3 children whose income is $1,000 a month, who have no alternative accommodation and who are not able to pay a rental of $500 a month because it just couldn't be managed. So you bring in the justice and equity element into the thing. And I wonder whether it may not be possible through education and publicity to persuade the Canadian people that there is a difference between the eviction of people from their homes. There's also a difference between the eviction of rich people from their homes and the eviction of poor people from their homes, and that maybe some kind of justice and equity element should be brought into being. As far as the case is concerned, I'd say 2 things. I would say firstly that the media element and the element of publicity and the element of getting the media onto your side in relation to your case is a very important one. And newspapers are a very important part of your ammunition. So, for example, I mean, if you speak somewhere at a meeting and ensure that the media are present, I would say, largely, the governments are blowing hot and cold here. We expect the governments to be moral and so on. This is what they say in Geneva. This is what they say here. Is this the conduct to be expected from government, etc., etc.? And if you can get newspapers to carry those sorts of things about governmental conduct at courts and other things and what is happening there, and if you could get newspapers to carry more and more articles as your case approaches about people who die away from their homes, die because they don't have homes because of the cold, how these things happen and so on, and develop a kind of public education thing which all organizations should be responsible for. Because unless you get the media on your side, you've got very small chance of building the kind of consciousness you should. So I really think that apart from ensuring that the role players are part of it and they know what's happening and so on, it is very important to have the raising of consciousness, organized raising of consciousness of people, and the changing of their consciousnesses and their consciences. So if I mean, just to give you a little example, if you manage to persuade even 1,000 people more that your cause is a good one, it doesn't matter too much if you lose the case, because then you'll be able to persuade more and more people, and the next time you bring the case, you have a greater chance actually of winning it, because you've changed the value systems of society. So that for me is an extremely important area. And I would have thought that, you see, if your case was that the Bill of Rights, your charter, by necessary implication, gives people the right to housing, then I think that the Attorney General's argument may be a good one, which says just as a matter of interpretation, the right is not given and therefore throw the case out. If, on the other hand, your case was a slightly nuanced one, and I haven't studied your case to see how nuanced it is, that what you are trying to do is, at a factual level, you are trying to establish the violation of the Section 7 and Section 15 right. Now, the question is not whether the interpretation of Section 15 and Section 7 protects the right to housing, but the question is, in the light of the evidence you have, bearing in mind the consequences of homelessness and a number of people who die and so on and so on, whether on the facts you can say that the Section 7 and Section 15 rights of people were being interfered with. Not as a matter of law and as a matter of interpretation of Section 7 and 15, that will be part of it. But you're trying to establish, not that there's a right to housing given to people, but what you're trying to establish on the facts, that as a matter of fact, the Section 7 and Section 15 rights are being interfered with because of the degree of homelessness, the number of people who are being rendered homeless, the consequences of homelessness, the number of people who die, and so on and so on. And if you go at it that way, I can't see how then it is legally open to the Attorney General to argue that this is a matter of interpretation, because that would be a thing taking you out of your case. If your very case was, we are saying, we're not saying that Section 7 and Section 15 give people a right to a house. We are saying that the government has to take some steps to ensure that the plight of the people who are being subject to tremendous indignity, their lives are being threatened, they are being treated unequally, their position must be put right in some way by the government, which is a slightly different case. So I would simply have that to add in relation to how you build your case, so that you emphasize on the facts. It's quite important. Unless the Attorney General says, okay, we are prepared to accept these facts as true, and we can argue whether the rights have been interfered with on that basis, then you can argue it without evidence. But if your case is a case of fact, then that's how you'd argue it. But that's all I would say. Thanks.
I'd like to go back to a point that you raised at the very beginning. You started off by saying that issues of poverty and homelessness are the consequences of the structure of society that we've chosen. And my question is, in the context of litigation, and I'm working on this for Right to Housing case, in the context of litigation, are courts institutionally capable of seeing the systems? I find that courts tend to be a bit impatient in identifying cause and effect in a very linear and short-term confined way, as opposed to having the patience to hear the ways in which a number of different multiple factors come together to build those structures. And to the extent that multiple pieces of law are the building blocks of that structure that sustains violation, how do we encourage the courts to have the patience to see the system as opposed to isolated moments?
Okay.
But first off, can I say I learned more in the last hour and a half than I have in any other hour and a half of my life. Thank you. But then I'm particularly concerned with your last comments, which I really think might help us very much in the case if we can explore more deeply. You said we shouldn't be asking for a right to housing, but we should be, we have to be saying that Section 7 and or 15 of our charter are violated. And we have to be saying, in effect, that they're violated because housing is a necessity of life, and these people don't have that necessity of life, and Section 7 and 15 imply they should be given. So how do we parse it in a way like you suggested and say that's not a right to housing? isn't it, whatever way we say it, don't we have to argue that there is some minimal right to housing? Otherwise, because if you don't have a house, you don't have security of the person, you don't have the right to life, and so on. So I really would appreciate some more assistance on that point, which might be very crucial. Thank you.
Okay. Michael.
I'm interested in how we can make connections between a number of social and economic rights. It seems to me the danger in our work in community, in the courts, in the legislatures, is that we can focus on the right to housing or the right to adequate standard of living or the right to health or other rights and achieve some success in some area, but only to be sort of pushed back in others. And we'd like to sort of have all these bundled together. We know there's an emerging recognition of the right to the city as a kind of a collective set of rights that bundles together social and economic rights. So I'm wondering if you just some thoughts on how we can avoid getting so specific about one particular social economic right that we kind of lose the narrative on the fact that all the rights working together are critical.
Okay. As far as the structure question is concerned, I agree that courts won't see the point. The point I was making there is the political point, the media point, the publicity point. You're in your campaigning, in persuading ordinary human beings, regardless of the party to which they belong, to begin to understand that it is a consequence and therefore we are all responsible. In other words, it's really the public campaigning point. And you know, I've always emphasized that you don't go to the courts alone. And I'm not talking about the courts alone. So until such time that a critical mass begins to understand and begins to say that yes, it is a consequence of the structure of our society, judges will have to reflect that value. So it's how you create the milieu, how you create the value system that I was talking about there. As far as the second question is concerned, there is a difference. That what the state is trying to do is to keep the facts out. And what I am saying is that you have a greater chance of success if you persuade the court that you have to have regard to the facts before you decide whether, whatever you call it, it's not the label that I'm interested in. You can call it, whether equality includes the right to housing or whether the right to dignity includes the right to housing is not a legal question alone to be determined out of its context. It is a factual question because it is a matter of degree and so on and so on. And a lot depends on the nature of the problem. So that if thousands of people are in the street, 300,000 people without homes, it's a substantial violation of the right to their dignity, as distinct from one person having, it's an isolated problem, it's a different thing. So all I'm saying is that before the court decides the question, it must have regard to the facts, because your case is not simply a technical legal one, bent on simply interpretation, but your case is largely based on the fact, and the court must have regard to the facts before it throws the case out. And that's the only point you make at this stage. And then if after the court has regard to the facts, it says you have no case, then I'm afraid that that's basically the end of that. Then it comes to a matter of definition. But I think you've got to get the facts in. And what I sense is that the government is trying to keep the facts out. And you've got to say to the court, look, you can't decide this case without looking at the facts, because our case is a factual question. Now, what we did in South Africa, coming to the third question, when we were organizing, is that we had a housing action committee, we had a health action committee, we had a pensions action committee, we had a detainees support committee, etc., etc., etc. And all those were linked together into a broad-based organization called the Civil Action Group or something. So I agree completely that over-concentration on one right above another is a very bad business. But that question is an organizational one, that what you're going to have to do is form different organizations responsible for different things and have perhaps some kind of umbrella organization which makes sure that there is a degree of consistency and so on and so on. But that's the organizational model that I would propose. That doesn't mean it's a mechanical organizational model which says everybody must pay equal attention to the same thing. Depending on the context, depending on what's happening in society, today may be the day for housing. Tomorrow may be the day for health. The day after may be the day for something else, you know. You might even, there are many ways of organizing. You could say today is the National Housing Day. Declare it and organize around it. National Health Day. Organizing is a very interesting business. You can do loads of things.
Great. So I'm ready for another 3 questions. Abby?
Just like Peter, I'm just so inspired by your wisdom and insight. And I guess my questions are similar to Peter's and Faith, although I'm coming in from a slightly different perspective. And I had the privilege of visiting your country during the World Conference Against Racism. So my question is related to that. There is another, your comment about the structural poverty as a structural issue. And in the context of Canada, there is another wrinkle to that structure, which is, I guess, in some ways similar to the South African history on the way that we treat the First Nations population and people of color in this country. So in fact, there are a lot of, as a fact, there are a lot of studies that show that people of color, Aboriginal, are more likely to live in poverty 2 to 6 times, depending on who they are, where they live, and so on. So we're part of the campaign that we call the Total Poverty Campaign, and trying to raise some awareness around this issue. So on one hand, I think a lot of people might understand sort of the economic structure as an issue, sort of like the capitalist society and all that kind of stuff. On the other hand, in Canada, I think there is a lot of reluctance to accept that race, in fact, is part of the structural problem. And it's very difficult to have that kind of conversation. So, in fact, we took something like your advice to do a lot of media work to talk about race and poverty to some very degree of success. But I think because of the reluctance of the state and also the court to talk about that as a structural issue. So sometimes I think I struggle, as a lawyer, do we actually raise this issue? But then on the other hand, the facts are race is an important issue, so is gender, and so is disability. So my question is, given that is the case, how do you best take advantage of the facts when you talk about and the importance of highlighting those facts, particularly in the case of right to housing, or in any other kind of litigation that deals with structural economic problem that in fact has racial and other elements in it as well?
Maybe we'll just let you answer that one before we go to another one.
All right. I think that the wrinkle is an advantage in a sense, because I think that Canada has to confront the race question. And my sense is that the more you try not to raise it out of a kind of thinking that it will do you harm to raise it, the more I think you unwittingly but inevitably place yourself into a deeper and deeper hole from which you would never come. Now, my sense is, even though I don't understand the conditions as well as I should, that any delicacy about refusing to face the race question walks into quite clearly the agenda of those who don't want to face it. Mm-hmm. That is precisely the attitude that they want to create, and therefore it is essential to raise it. And interestingly enough, while structure is a political thing which you'll have to raise with society, race is, and discrimination is a different matter, because you can work with people and you can raise race as a problem under the equality rubric a lot more strongly than you could raise more general economic structure, I think. So in a way you are at an advantage in relation to race, because you can do two. You have to raise it, but the fact that it's more difficult to raise is somehow compensated by the fact that courts understand this a little bit more, and therefore courts would help you if you do your thing properly. Structure is easier, economic structure is easier for you to raise with people without race. That's your advantage there. But your disadvantage is that courts are a long way away from either touching it or beginning to understand it.
I'll echo the comments of my colleagues, Davey and Peter, and thank you very much. It's been very educational listening to Justice Yacoob.
Sorry, you.
Zak.
Okay.
Zak. It's been a great pleasure listening to you. In getting away from the kind of larger litigation and the right to housing litigation, one of the other things we're trying to work on is some strategies for raising kind of international human rights really at the early decision level. So in Ontario, it's not courts who make decisions with regard to evictions, but rather an administrative tribunal called the Landlord-Tenant Board. And so we're looking at strategies to get these administrative decision makers to take into account international human rights law and the right to housing and the commitments that Canada has made internationally there. It's going to be easier for us to do, I think, in situations where we're dealing with government, so where we're dealing with kind of social housing, and for the courts to kind of understand those type of arguments in relation to social housing. Where I think we're going to have some problems, or much more problems, is in dealing with private housing, where private individuals or probably the hardest cases are going to be private individuals as opposed to companies who are providing housing, maybe even what we tend to call kind of mom and pop operations, where they're renting out a room and trying to evict someone from their home. We don't have in Canada, as you well know, kind of a section 26 of our Constitution, or at least it doesn't say what section 26 of your Constitution says. But nor do we have kind of the guidance from our highest court that we have in South Africa. I wonder what kind of arguments you have about kind of the nature of providing housing and how that really changes the kind of normal economic contract relationship that we might be making at kind of those in front of those decision makers at first level.
Well, that raises a very, very interesting question, because, well, firstly, I can't answer it properly because I don't understand I don't know anything at all about what your housing tribunal legislation says, what the powers are and what they're supposed to decide, and so on and so on. So a lot depends on that. On the assumption that the housing tribunal is not simply required to determine whether the person is occupying lawfully. Because if your housing tribunal legislation says that the only thing you have to decide is whether, in terms of the agreement between the parties, the person has a right to stay there or not to stay there, then it's a much more difficult thing. Then you've got to go a wholly different route. And that raises, interestingly, another question which has been rearing large in South Africa for some time, and our courts have not yet dealt with it. And that is the issue of the horizontal application of the Bill of Rights. Now, in our Constitution, equality rights, or the obligation, the non-discrimination obligations are placed on the state and on everyone in no uncertain terms, so that the non-discrimination elements, to the extent that they have to be taken into account in contract law, because it's already horizontally binding, you can take into account non-discrimination in developing contract law in a way. But our Constitution also provides that people, that civil society, human beings and corporations will have obligations in relation to some of the rights in the Constitution to the extent that the right may permit. A very woolly clause, which we've not fully, hardly decided on yet, because the case hasn't come. But what it means is that to an extent, it is not only the government who is bound by the Constitution or the Bill of Rights or the Charter of Rights. Because it won't do for human beings to continue violating these rights in relation to other human beings, but the government is supposed to obey them in relation to other people. And we've been fiddling with the notion, just fiddling at the moment, and hopefully we'll do more about that later, because we've refused to hear many of these cases, whether contract law must be infused by the Constitution. And the kind of questions that come up are whether, for example, clauses in a contract which prohibit some of these cases are dealt with by law, but clauses in a contract which prohibit, which allow, say, the cancellation of a contract and the forfeiture of all the money that they paid on a single breach without notice, would meet the values of the Constitution. Whether the contractual rule which says that where people undertook to negotiate in good faith and one party refused to undertake in good faith, whether that law complies with the Constitution. So I think there is a level of law which can be developed at the tribunal level, which says that contracts too must be interpreted in the light of the provisions of the Charter. And you start on the basis that unless people expressly say so, people in Canadian society would not want to act contrary to the Charter. So if there are two possible interpretations of, say, a tenancy contract, and if the one interpretation was more consistent with the Charter than another, you could possibly get your bodies to build up a rule which says, okay, I've got to take the Charter into account. This interpretation of a contract is more consistent with the Charter than that one, and I think that people in Canadian society want to comply with the Charter because people in Canadian society regard the Charter as extremely important, etc., etc. That's why I prefer this interpretation. But difficult for me to go any further than that without knowing precisely what your laws say. But I think, again, all laws in their context are capable of any interpretation. I'm sure if some imagination applied will bring you some results.
Maybe we could just invite any of the members of the panel who've been contemplating on this, whether there's any further comments or questions to add in just as we wind up. And we can continue our discussions over some food, but we should be winding up in the next few minutes. So, Barry, do you have...
Yeah, just a couple of very brief things, and I would echo what Peter said. I've been in hundreds of seminars over the years, and this is a topic I know quite well from some experience, and frankly, I've learned more than in almost any other seminar. So this has been really useful and not at all unhelpful to some of the things I hope to be able to make a difference on in Parliament. But I wanted to raise two quick things. One is, I think what Justice Yacoob, what Zak was saying really has to be reflected on well, which is there's
See how hard the rich people find it to discriminate against the poor.
yeah. That I don't read necessarily what he was saying as being, some kind of sleight of hand where you try to convince them that you're not talking about the right to housing as at all relevant. I mean, that you just can't get away from that. It's infusing the argument, but it's a matter of ordering the argument and emphasis, and how the facts plainly fit into the interests that are explicit in the Constitution, security, as it's informed by equality. That has to be just front row and center, so that, because otherwise it's easy to play into, help reinforce their own formalism. If you start talking about the right to adequate housing as being what you want to read into the charter, and they begin to, even as you're trying to make the argument, which makes every bit of sense, they begin to see it as, well, it's separate. If you're asking us to read it in, it's separate, and you have to somehow work with that nuance. And so one of my last articles in Economic and Social Rights called "Reaching Beyond Without Abandoning the Category of Economic, Social, and Cultural Rights" might be helpful from a mindset perspective on that point, because it also comes with some reflection about myself having fallen into a little bit of aspects of the formalistic trap because of how rights get argued as these kind of containers that interact with each other, and you lose sight of the underlying facts and how they relate to broader interests. And security is, at some level, we might even want to think we have a better constitution, because security is just such a rich concept that you can work with. And almost, it's like a problem to think of it too much like that. But at some level, one can work with the richness of the concept we do have, versus trying to say we need another concept, and there's a good reason it should be part of it. The other thing is, I'm just thinking back to ages ago when Leilani was at University of Toronto, not long after I'd started teaching, and she was focusing on a project having to do with in the Middle East with the notion of healthy communities, and the idea of healthy communities, notions that assist it, like right to a city and things like that. I'm increasingly thinking that kind of notion has to be front row and center in so much of economic, social, and cultural rights advocacy. How one can get it into the structural dimensions of court cases is perhaps another challenge, but making sure that we're not part of sort of atomizing rights too much, and that we understand it's about healthy social relationships, but quite often that can be drilled down to healthy communities in really specific social historical circumstances, whether it's specific Aboriginal communities, whether it's many of the pockets in the city of Toronto that many of us have no clue about, but are actually communities that are sort of crying out for a holistic approach, or whether it's other pockets of deeply unhealthy communities in this country. I keep coming back to that concept as probably something that can do some work and could appeal to a certain breed of judge that is now starting to populate the courts, because we now have 6 or 7 years of Harper government appointments of federally appointed judges. A lot of them will be judicial conservatives, as in they have some kind of clear hands-off view, and that it's not necessarily a bad thing if it's consistent. Some of them will be ideologues from a kind of a more right-wing conservative perspective, and I don't know how many because we're not tracking it, but I bet you an awful lot of them get the whole idea of the value of community and fairness of why some communities shouldn't be disempowered when others are sort of, without having earned it, much more affluent. There may still be that progressive conservative strand in a number of the judges that have been appointed, and it might be helpful.
Zak, the last word?
I agree with that, and I agree particularly with the notion that unless we stop thinking in boxes, we're really not going to get very far in this very important work. And I would echo that in no uncertain terms. And really, rights are interrelated. They really are indivisible. And one right can come out of another right. But whether it does, you see, it is possible to argue, again, just to flesh that point out a little bit more, that the extent of the problem and the effect of the problem, in other words, the factual circumstances, are highly relevant to determining whether the government should do anything. And therefore, the size of the problem and its effects must be taken into account. That would be the sort of thing. But I must say thank you very much, everybody, for hearing me. It's nice, actually. It's nice to be, not to be a judge, and to talk about things that matter to us in a direct way, without overemphasizing the role of the law in the solution of problems. It's been very interesting for me, and thank you very much for having me.
So you might gather that your remarks have been very much appreciated and valued.
Thanks very much.
From some of the comments. I just want to echo that. I remember when I visited a person whom I know you know quite well now, Sandy Liebenberg, when she was working with your technical committee on drafting the Constitution, and we were debating all of these issues about social and economic rights. And people like Craig and I and others were flocking to South Africa to tell everybody, oh, yeah, social and economic rights have to be justiciable. Everybody accepts that now. And then, of course, when you ended up with justiciable social and economic rights, Sandy talks about then coming back to us, okay, we've got them now, so how did you argue this in your country? Well, I don't know. Like, well, where are these countries that you told us about that have social and economic rights? Well, there's not, maybe India has interpreted, and they said, you mean we're really all alone with this? And we said, yes, sorry, we kind of misled you on that. But, in the end, we said, we just hope that your constitutional court is good on this, because we're all watching. And what an incredible stroke of luck that we had, that it was people like you who took it through that first decade. And I just have one story about that. When we finally got a complaints procedure for social and economic rights before the UN, when in the working group, Canada lobbied like crazy to try to stop this because they hate the justiciability of social and economic rights. And so and on the last day when we were about to adopt it, they had almost a majority of states say, no, we've got an amendment. We want to put in a reference to a wide margin of discretion, that these issues should be left to governments. And the chairperson of the working group handed a note to me saying, Canada seems to have got this strong lobby. We have to put something in about deference or something. And so the group of us were scrambling around, and somebody said, well, what did Zak Yacoob say about it in Groupum? So we pull out the Groupum decision. And we have a range of policy options, may be possible, but they have to be reasonable. And so we send this note up to the chairperson, try out Zak Yacoob's language. So she puts that forward, and we got it in to the optional protocol, and we kept wide margin of discretion out. And I know that people are going to be leaving this workshop, and we're going to be saying, how did Zak Yacoob say that again? I really want to thank you for coming.
Thank you.